Hello, I'd like to talk to you today about an aspect of our tax code that some people thought had almost been forgotten about. I'm thinking in particular of the GAAR, the General Anti-Abuse Rule. Now, you may recall that amid a lot of publicity and after not inconsiderable consultation, the GAAR officially went live as part of the Finance Act 2013, when that received royal assent in July of that year, 2013. But since that date, and we're now, 4¼ years on from when it got royal assent, one has heard from the revenue side very little about the GAAR. And some people felt that although the GAAR legislation had been enacted, it didn't appear that it was being put to any use. In fact, there was quite a bit going on behind the scenes that many of us were unaware of. And what I can now tell you is that the very first GAAR Advisory Panel opinion has recently been published. The point here is, remember, HMRC feel that your or my client has been using a nifty tax planning stratagem that they think probably falls foul of the GAAR principles. Their first step, if they feel it's a serious case, is normally to ask the GAAR Advisory Panel for their opinion. Now, the GAAR Advisory Panel is a small group of independent tax experts headed by, I think it's an ex-Magic Circle lawyer, but there are about 6 or 7 of them, I believe, and broadly what they're going to do is they are going to advise the revenue whether, in their opinion, the particular stratagem falls foul of the principles about the GAAR enacted in Finance Act 2013. Normally, as I say, the panel, when it sits to hear a particular case, probably will consist not of all of them, but perhaps of 3. No doubt the chairman and 2 others, I would have thought, typically will be the case. And as I've said, very interestingly, to indicate that things are not dormant, the first official opinion was published on the 3rd of August 2017. Interestingly, when we read about it, and there's quite a lot of detail that is now available in the public domain, the opinion, perhaps not wholly surprisingly, relates to an employment reward case. It's to do with the bonus, in other words. And what had happened was that this particular company, which is obviously anonymised, had decided to provide 2 members of staff with a bonus of, I think in total, £300,000 or thereabouts. Now, normally, if you or I were receiving a bonus of that level, clearly income tax and national insurance, absolutely no problem, would be levied in those circumstances. But the employer took tax planning advice and they came up with a scheme under which they hoped that the employer would still get a corporation tax deduction for the £300,000 bonus, but in the hands of the staff, the £300,000 bonus would be completely tax and national insurance free. Sounds too good to be true, doesn't it? And of course, as you'll see, it was. What happened was that it was a bonus, obviously not provided in cash, because that would be straightforward. It was provided in the form of gold bullion. Now, some of you may recall that a good few years back, there were a number of mainly national insurance avoidance arrangements involving things like gold bullion and platinum sponge, I remember, was another one, where bonuses were provided in kind rather than in cash, and the main purpose was not to avoid income tax on the bonus, but to avoid national insurance. But of course, all that has long since been dealt with. So you might say, well, hang on a minute, if this company was providing these 2 lucky members of staff with a bonus in the form of gold bullion to the value of £300,000, surely that's going to be caught under the normal benefit in kind rules anyway, that would then not also give rise to a Class 1A national insurance charge. But it was a bonus with a little bit of a difference. The published information that is available is perhaps not as detailed as obviously the GAAR panel received, but one can nevertheless get a reasonable idea of what went on and why it was initially felt that this might be a viable tax planning arrangement. What happened was the employer had ordered the gold from a supplier. They had, as it were, delivered the gold to the two members of staff, and the two members of staff had probably sold the gold back to the supplier. Now here's the rub. Normally you would have expected the employer to have paid for that gold. Under this deal, as I understand it, it was the staff who paid for it. So in other words, they'd sold it, and of course the proceeds that they'd just received, they immediately, in whole or mainly, returned to the supplier in payment for that gold bullion. But what it did, as far as their employer was concerned, was that it created a credit balance in, I think it was their director's loan account with the company. And as you all know, if you've got a credit balance in your director's loan account, let's say you're running a family trading company, and you've got a credit balance in your director's loan account, that money, of course, the credit balance in your director's loan account is bunce. You can take it out as and when you like, and of course there is no further tax charge on it, because in most cases it already reflects money that has been fully taxed. That was the interesting point here, because in the relevant ITEPA legislation, and it's obviously the background ITEPA legislation is very convoluted in this area, but there is a little glitch. I think it's section 554 of ITEPA, and there are a load of letter suffixes if you go to 554, and somewhere in that legislation there is a provision which should say if this particular arrangement is used for tax avoidance purposes, it is ineffective, and that requirement is not present in the legislation. In other words, it's a technical oversight. And that was presumably why the advisor, and we don't know who the advisor to the employer company was, one suspects it was probably one of the big four accountants, but we don't know. That was why they jumped on that apparent loophole and devised this scheme for their client's advantage in those circumstances. So that was the position, as I say. The employer hoped still to be able to get a corporation tax deduction for the $300,000, but the two members of staff, who are called Mr. X and Miss Y, would not pay tax or national insurance on the bonus that they received if the scheme was effective. So the tax planning arrangement, in other words, was attempting to provide bonuses that were totally free from any charge. And under the GAAR, when the Revenue referred it to the GAAR Advisory Panel, the basic question that the Advisory Panel have to consider is what the taxpayer has done, the company and the two members of staff, does this amount to a reasonable course of action in all the circumstances? And the interesting thing about this Advisory Panel opinion is that because it's the first one, it gives us information about quite a lot of the background and procedures that are going to be involved with the GAAR as we, over the years, increasingly become more and more familiar with it. And the panel focused on three questions. And you'll see in the notes which go along with this talk, I have set out the three questions that in particular they were looking at. The first one was to ask, did what the taxpayers do involve any contrived or abnormal steps? Because if, hand on heart, you could say, that looks a bit contrived or abnormal, you're probably halfway to being GAAR'd. So that was the first thing. The second question they looked at was what was done consistent with the principles and policy objectives of the legislation? In other words, was it part of the government's intention when Section 554 and all the related sections with their suffixes in it, ITEPA, were constructed a few years back, that this should give rise to a tax-free benefit in certain circumstances? And the third question, and this I think is the most interesting one, was there a short shortcoming in the legislation which was being exploited. Now, as you might guess from what we've already said, when the GAAR Advisory Panel considered these three questions, they clearly said yes, yes and yes. Well, yes, it involved contrived or abnormal steps, because they said, why do you use gold bullion rather than simply pay the guys cash? So, yeah, that's not normally what you might do in relation to your typical run-of-the-mill bonuses. So it's pretty clear that it involved contrived or abnormal steps. Was this consistent with the principles and policy objectives of the legislation? Probably not. So answer not to that question means, again, it is more likely to be GAARable. Was there a shortcoming in the legislation which was clearly being exploited? And the answer is yes. It relied on a lacuna in ITEPA that perhaps shouldn't have been there but was, and as a result, in those circumstances, the advisory panel had little difficulty in saying that they thought it should be caught. I've given you a quote from their concluding comments. This is a clear case, they said, of associated taxpayers seeking to frustrate the intent of Parliament by identifying potential loopholes in complex interlinking anti-avoidance legislation and arranging a series of intricate and precise steps to exploit those loopholes so as to gain an unexpected and unintended tax win. And they go on to say it therefore shouldn't come as any surprise to people who've been listening to this that therefore we conclude that the steps taken did not represent a reasonable course of action in those circumstances. In other words, as I've said in the notes, game, set and match to HMRC. Now, one of the interesting things that struck me about this case is the bonuses for a first-off decision were relatively modest. £300,000. What would the tax on that be? Well, if they're 45% taxpayers, about £130,000. So one is a little surprised, if you like, that this particular one was picked as the first instance. What I think I could safely assume is that it was probably the result of other, what are usually now termed, following arrangements. So, yes, this was a case that was picked, but there may have been, let's say, some investment banks who had been similarly remunerating some of their senior members of staff, where the bonuses did not total 300,000, but perhaps total 30 million. And so I suspect this wasn't a unique case on its own. Indeed, it would be most unlikely if, for example, we were looking at a tax planning wheeze from, say, one of the big accountancy firms. They would have been using it probably quite widely amongst a number of their employer clients in those circumstances. So one could certainly envisage that to be the case. Now, as a result, what clearly will probably already have happened is that the Revenue will now have issued counteraction notices. And broadly, what those counteraction notices under the GAAR are doing, it is saying, in our opinion, that stratagem does not work. The bonuses, therefore, are subject to normal tax and national insurance. There's no reason, obviously, why the employer shouldn't get a corporation tax deduction. I don't suppose for a minute the Revenue are concerned about that. But what they are concerned about is the fact that the employees, ostensibly, were not going to pay tax or national insurance on their large bonus receipts. And that, one would guess, is what the counteraction notices were all about. Indeed, as part and parcel of their judgment, the advisory panel actually said, had cash been used and gold not been involved, neither the company nor the employees would have been in a substantially different economic or commercial position. And that, in essence, is what justified their determination. One little point to note is that even if the advisory panel had taken an opposite view, notice the Revenue under GAAR are not obliged to follow their view. They're still at liberty to disagree. So even if the panel had actually given the ploy the thumbs up and said, sounds okay to us, if the Revenue disagreed, they could still pursue it with counteraction notices, and presumably it would then have to end up in the courts, one way or t'other. But one would hope in the early days, certainly, if the GAAR says, yeah, we think that's caught, no doubt the Revenue would rub their hands and go ahead with the issue of the counteraction notices. If, however, they said, we think that's okay, one hopes that they would withdraw their complaints, but we don't know. There are, however, just a couple of things that I ought to mention. Just a couple of short extracts from the panel's opinion that I think are worth highlighting. Again, you will see it in the notes. It's in, I think it's paragraph F on the second page of the notes that I've written to go along with this talk. And they're just two extracts, both quite short extracts, the GAAR panel's opinion. The first one highlights the fact that merely because a particular action is covered by legislation, that does not mean that it cannot be regarded as abnormal or contrived. So in other words, because it has been envisaged by the tax legislation that this might happen, it is not a defence to say, therefore it can't be abnormal or it can't be contrived. I think probably that is a perfectly reasonable statement. But the one I am a little bit more concerned about is the second extract. And the reason I'm concerned about it, I think, will become clear if I actually read out the extract in full. It's only 4 lines long, but it says this. The course of action taken by the taxpayer aims to achieve a favourable tax result that Parliament did not anticipate when it introduced the tax rules in question, and critically, where that course of action cannot reasonably be regarded as reasonable. Now, it seems to me that what that means is that HMRC and the GAAR Advisory Panel now have the power to say that something which Parliament legislated did not really mean what it quite clearly says, simply because the matter wasn't originally considered in sufficient detail or with sufficient care. That, in my opinion, is worrying. I've said on the slide it's frightening. Put it stronger. I've also suggested that perhaps this particular aspect of the GAAR legislation, in the light of the first year or two of the use of the GAAR, perhaps ought to be revisited, although my gut feeling is that it's probably most unlikely to eventuate to happen. But what it means is that the idea that in the past we could advise this or that client to take advantage of a known loophole in the legislation, which has always been part and parcel of tax planning advice, the GAAR suggests that if you're aware that something is a loophole and you encourage a client to take advantage of it, that undoubtedly could be GAAR'd, especially if the other questions that we referred to can also be decided, can also be answered in the Revenue's favour. So I have to say I am a little concerned about that. It is a bit too big brotherly for my liking. But it'll be fascinating to see, because I suspect we're going to start to see more and more GAAR Advisory Panel's opinions coming through from now onwards, and it'll be fascinating to see how this particular one develops. But thank you for listening to this talk. My name is Robert Jamieson.